and welcome to Accredited Real Estate Schools. We are going to be talking about top practice questions to help you prepare for the California Real Estate State Exam. My name is Schyler Church. I am a California real estate broker as well as a member of the education department here at Accredited. So we're going to go through some top questions, but if you like this video, make sure to give it a good thumbs up, subscribe to our YouTube channel, and comment below with any questions, comments. We'd love to interact with you guys. So let's get going and start with question number 1. With regards to fiduciary duties, a real estate broker is to the seller like A, trustee is to the beneficiary, B, a trustee is to a trustor, C, a grantor to grantee, D, all of the above are correct. So what I always like to do is, remember, we like to dissect the question. So we're talking about a real estate broker to the seller. So the broker is an agent to the seller. And when they're an agent to the seller, they're acting on behalf of their client with a certain warranted authority that's provided to them. But they have to do so with a fiduciary duty of utmost care, integrity, honesty, loyalty, respect, confidentiality, competence, keeping them informed, disclosing material facts, anything and everything you can think of that's good. So you're acting on behalf in the best interest of your client, right? That is basically what we are as a broker to our seller. Well, what does this kind of emulate? Let's break it down. So a trustee to the beneficiary. Remember, the trustee is the one that holds bare naked legal title. When a trust deed is used, and we use those primary as a loan with that coupled with a promissory note, well, that trustee is that independent third party. They hold title. So if the trustor, the borrower, defaults on the loan, well, the lender, what we also call the beneficiary, then wants to see if they can get the money back by, what do they use? Well, that deed of trust that actually hypothecates the loan. It puts the house as collateral. So the trustee then would step in and proceed with a trustee's sale to then be able to help the beneficiary get their money back. They're acting on the best interest of the beneficiary. They are still a neutral third party, of course, but for the beneficiary to get money if the borrower, the trustor, were to default. So that's kind of very similar to what we're talking about. So that looks to be a good answer, but is it the best answer? Let's see. A trustee to a trustor. So remember, the trustee is the one that holds this bare naked legal title, and all they have is power of sale. That's it. And the trustor gives the trustee power of sale. So that doesn't really have anything to do with this. The trustor is the buyer-borrower. They're the ones that are taking on the debt, and they pay this debt back to the beneficiary, the lender. But the trustee is the one in the middle that holds that bare naked legal title. They're not really in the middle because they're a disinterested third party, but that trustee just holds power of sale if the trustor were to default. So they're not really doing this in the best interest of the trustor. They're doing so for the beneficiary. So B does not look to be a good answer. C, grantor to grantee. So when a grant deed is used, that's what we convey, transfer title of real property in the state of California. We primarily use grant deeds to do so because of those implied in warranties and covenants that are when we use a grant deed. So it has better protections. The grantor is the one that is granting the property to somebody else, conveying that property to someone else. So grantor is giving the property to the grantee. But does that really have anything to do in their best interest like the fiduciary duty does as a broker to their seller? No, it really doesn't. It's just conveying of the property from the grantor, so usually the seller, to a buyer, the grantee. It doesn't usually need to be a seller buyer. It's just when they're transferring the title to someone else, grantor to grantee. So not all of the above. So the best answer is A, trustee is to the beneficiary. That is very, very similar to what a real estate broker has to the seller when we're talking about fiduciary duties. A weird question, you have to know a lot about it. So basically comparing and contrasting concepts. 2, usually a broker has a right to a commission only on the basis of negotiations, which he completes during the term of the listing agreement, unless A, the listing agreement has a liquidated damages clause. B, he brings a court suit against his principal. C, a protection period clause is contained in the listing agreement. D, the listing involves the exchange of properties. So, as always, let's look at the question. Pretend this question is like an essay question. There weren't any answers. We didn't even look at the answers yet, but let's pretend it's essay. So a broker has a right to a commission only on the basis of negotiations which he completes during the term of the listing, unless. So they're saying here, when does a broker actually have a right to a commission when it didn't actually happen within the terms of the listing. So if the listing had expired, how could the broker actually get paid a commission? Well, if the listing had expired, when is the broker entitled to get a commission? When that broker protection period clause is in effect. That is where it says, hey, if that is signed in the listing agreement, the broker says, I get a right to a commission during the listing period, but also if I give you a list of names of everybody I've worked with and they buy the property within a certain period of time after the listing has expired, well, I'm entitled to a commission. So that is where they could actually get a commission even after the listing has expired, if that protection period clause is in effect. So what looks to be here? The best answer would be C. A protection period clause is contained in the listing agreement. But of course, always make sure to read all the answer options to figure out the best answer. So listing agreement has a liquidated damages clause. Remember, that has nothing to do with us as the agent, and we are not. That is a liquidated damages clause is actually in a purchase agreement where the buyer and seller are agreeing to predetermined amount of damages if somebody were to breach the contract. So that doesn't really have anything to do with us. Brings a court suit against his principal. No, that's not when. This is for us if we're having a problem actually collecting a commission that we're entitled to. Then we would go and do so. Go into civil courts. And remember, who always does that? The broker. Listing involves the exchange of properties. Well, we could be entitled to a commission because of the exchange of the properties during the exchange period, but not just because there was an exchange occurred. So the time that we could get a commission, even after a listing has expired, if it didn't happen within the term of the listing agreement, well, that would be if a protection period clause is contained. 3, how much of the broker's own money can he keep in his trust fund? So his trust account, well, how much money can he keep? A, $200. B, he cannot commingle his own funds with those of his clients. He must make arrangement with the bank for enough money in the account to cover service charges. C, $100. D, $25. So a trust fund account, remember, this is a fund that is entitled, or it's just for client money, funds that you've been entrusted by your clients to hold on their behalf. And if we have this trust fund account, by law, they say we can keep up to $200 of our money in the trust fund account without being guilty of commingling funds. Anything that exceeds $200, we would be guilty of commingling. So this is just to be able to handle those service charges, but we cannot have anything over $200 of our own funds. That would be guilty of commingling, but the law states we can have up to $200. That is okay. 4, in an open, non-exclusive listing situation, the broker who most likely would be paid a commission is the one who has A, communicated acceptance of offer to the offeror. B, produced a person who would purchase under the terms of the listing. C, obtained a substantial deposit with an offer. D, secured acceptance to an offer. So remember, an open, non-exclusive listing situation, this is a unilateral contract where you can have open listing agreements with multiple brokers simultaneously. And whoever shows that they are the procuring cause is the one who is entitled to a commission. Well, let's see here. So in this, who would then be able to show that they're the procuring cause? The best way to show that you're the procuring cause is you presented the offer, that offer was accepted, and you communicate that acceptance back to the offeror. That is then when we have a valid and binding contract. And that is where we can show we are the best shot of being the procuring cause of being that agent of this sale. So that would be the best way. So let's see here. Communicated acceptance of offer to the offeror. Yep, that is basically what I said. And in this question, it does seem to be the best answer, but let's make sure the other ones are not correct. Produced a person who would purchase under the terms of the listing. So we might be entitled to a commission under that, but it's not going to be the best way of showing that we are the procuring cause because there wasn't necessarily an acceptance there of the sale. So you have to be the procuring cause of the sale. So yeah, you might be entitled to a commission because you satisfied what they said they wanted, but that doesn't really mean much. C, obtained a substantial deposit with an offer. Remember, you don't need to have a deposit with an offer. That's not a requirement, so that would not be correct. Secured acceptance to an offer. So you can secure the acceptance, But that doesn't mean much because remember, the valid and binding contract requires that that acceptance be communicated back to the offeror. Then we have a valid and binding contract. That is how you actually properly get the contract, a valid binding and contract, by communicating the acceptance back to the offeror. So secured acceptance to an offer, well, what does that mean? How did they secure it? We don't know. The better answer is A, because that is actually how you get the contract, a valid binding contract, and would show that you're the procuring cause then of this sale. 5, what would an appraiser use to project gross income from an apartment property? A, actual rent. B, economic rent. C, accrued depreciation. D, none of the above are correct. So an appraiser using to project gross income for an apartment property. So apartment properties, they are income producing. They don't sell that often. They would use the income approach, the capitalization approach. Appraisers then need to figure out what the net operating income for this particular property is. And the way they would do so, and when they have to project that gross income, is they would look at what are the market rents out there for comparable apartment buildings. What are units out there that are similar getting in rent? And what's the market rent? And that is what we call economic rent. So the appraiser is looking at the economic rents to project gross income for an apartment building, economic rent. Actual rent could be below economic rent because it's been in contract or they've had a lease agreement for so long, for instance. And then accrued depreciation, that deals with the cost approach. None of the above. No, we do know economic rent is correct.
Thanks for watching. I hope this video was helpful in your licensing journey and your studies. If you liked it, make sure to give us a big thumbs up, as well as subscribe to our YouTube channel so we keep producing new content. But if you have any questions, or if you'd like to check us out for completing coursework to be eligible to take the state exam, or even for preparation to help you prepare for the state test, we have tons of options, and I have our website listed below. Otherwise, I'm Schyler with Accredited Real Estate Schools, and thanks for watching.